Sorry for the disturbance as there was network issues. We are starting with the event again. I welcome our esteemed guest.
Am I audible?
Yes, sir. Yes, sir, you're audible. We are really sorry as there was network issues and we are starting up with the event. Students, am I audible? Let me give you introduction of the event again. We are having a guest lecture on medico-legal startup. Good afternoon, everyone. I, Miss Ishita Tyagi, coordinator of today's guest lecture, welcomes you all. As we all know, IIC Institutions Innovation Council of IMT Colleges of Law is organizing a series of events to inculcate among the youth the spirit of research, innovation, and entrepreneurship. Today, we have Advocate Prabhat Kaushik, who will be our esteemed speaker, and he will be speaking on the topic Medico-Legal Startup. Advocate on record, Supreme Court of India, Sir is learned, and he is here with us to grace this event. Welcome to you, sir. Over to you.
Hi, good afternoon, all. I hope everything is fine. And let's just start it because we have already, it's 12:23 by the clock. So today's topic is very a unique topic, and it's very new. And I feel really lucky to have with you all and to interact with you all on this very different topic. Sorry, my so as the topic says that it is a medico-legal startup. So what is it going to be? As we all know, we are being a law student, or we say a lawyer, and in law profession, this thing is very important for us to know that how the link between the legal and between the medical, these two fields may be different and may have two different streams, but they join with each other, and joining in a very in a manner which is very important even for the solving of very for the intricacies, if we say that sometimes very technical issues regarding uh, unnatural accident and death and poisoning, intoxication. So these all offenses can only be done with the help of medical. So now, what is the role of a startup in the medical field? In the medical field, if we say we all are learning, we all are students, and we must know that feel that these are giving a very new and new opportunities for us. Even in the medical field, being a lawyer, we can advise doctors, we can advise a hospital in a very if we have to run a hospital or a medical institution, there are so many things in which the law is required. For say the insurance, if we approach some hospital or some medical, if we so we find that first of all we have to deal with the insurance company. And now, what is the role of an advocate in this? The role of the advocate is very important for an insurance company, because the companies, they run out of profit, they make profit, and for making profit they knows the technicalities of law, how to derive profit or how to generate profit out of it. Only a lawyer can tell on, and only a lawyer can suggest or advise a insurance company regarding the profit making things and regarding the technicalities they can face while while they are dealing with their client, or we can say their patient. Now, first of all, we have to see that how a lawyer can help. A lawyer can help an insurance company by preparing agreement, by preparing the clauses of the agreement. Sometimes we can see that nowadays this is like, medical insurance is used very widely. So now we approach a hospital, and if we interact with the staff, if we interact with the insurance company, being a lawyer, if the insurance company interact us or contact us, we can advise them that see, there are so many things which we can add, and for that, medical knowledge of that thing should be known, like, so we can prepare agreement. And also for the doctors, we can prepare agreement for before conducting an operation, that uh, what are the what kind of a doctor can face.
Yes, sir.
Am I audible?
Yes, sir, you are audible.
Yeah, yeah, yeah. So this is all like, being a new stream, medical legal startup, as we were discussing. I think that facing a very technical glitches, like, so now we can advise a hospital, and we can advise a medical staff or medical doctors while we conducting the MLC, while preparing the MLC, that how it can be conducted in a manner so as to escape from the clutches of law. How can a doctor can save himself? Because if the MLC is not prepared with all the legal consequences, then it has consequences, and it may land even a doctor to jail. Now the sections which are applicable are the 304A of IPC if somebody is died because of the medical negligence. So, and also 176 IPC and 202 IPC. These are the sections of IPC which a doctor can face if he is not like, giving a true information, he is not giving a correct information to a police or to an investigating officer regarding the commission of an offense. So what does it says that this 176 of IPC says omission to give notice or information to public servant by person legally bound to give it. So a doctor is legally bound to give information to an investigating officer who has conducted the MLC or who has prepared the MLC. The other section, if we talk about, is 202 IPC, which says that whoever knowing or having reason to believe that an offense has been committed intentionally omits to give any information respecting that offense which he is legally bound to give shall be punished with imprisonment for a period of 6 months or with fine. Now, being a legal officer or being a lawyer, we can advise a doctor, we can advise the medical staff, we can advise a hospital that these are the things, how a MLC can be prepared, what are the steps to be followed while preparing an MLC, so that they are not to be like, face some kind of intricacies or some consequences like section 176 or 202. So we have to, like, and other thing is to make them aware about the medical negligence. Sometimes being a doctor, not being aware of law or not being aware of the legal intricacies, they are not, they sometimes unintentionally do such type of thing. Because if somebody, like, an accident case, or somebody is getting very fatal or fatal wounded, a very, a very serious patient approached, and they have to, in haste, they have to prepare MLC and all these things. So when they received a summon, and they have to appear before a court. So at the time of cross examination, they fail to give a correct details of how the wound was inflicted, what kind of weapon was used. And because for an investigating officer or for a court, it is very necessary for reaching to a conclusion, or to reaching this conclusion that how the offense has been committed. So for giving a correct detail, a medical officer should be knowing this, that what are the basic essential, and what are the guidelines which are laid by the law to prepare for MLC. And one more thing which is very important over here, that if a case of poisoning comes before a medical officer, he must be knowing that what kind of intoxication and what kind of poisoning a person has been given, like, hemotoxin or neurotoxin or something like it. Or there are so many things. So we have to, like, give them advice. We have to tell them that while preparing the MLC, these things has to be in detail mentioned in the MLC, medical legal report, MLR, or what can we say. So that to help the court reaching to a conclusion or giving a punishment to a culprit. Now, being a legal startup,
Network.
my my mic was muted. Hello, am I audible?
Yes, sir, you are audible.
Am I audible?
All of you, please switch off your cameras. These activities are being
So we can
recorded.
let.
So action will be taken against the student who is disturbing the event. Sorry for the disturbance, sir. You may carry on. Thank you so much, sir.
So we can, being a medical legal startup, we can even help the drug manufacturing company, because the drug manufacturing company approaches advocates most of the time to know about the law, which are very essential, very important for for clinical trials, and for drugs and cosmetics, and what drugs are prohibited, what drugs are not prohibited, what kind of substance which we can import, and what kind of substance which we shouldn't be import or export even. So there are so many acts even which we can let the companies know, like Drugs and Cosmetic Act, to regulate the import, manufacture, distribution, sales of drugs and cosmetics. The other thing is Drug and Cosmetic Act and the Drugs Control Act, uh, the Pharmacy Act, which is for the regulation of profession of pharmacy, and it is expedient to make better provision for regulation of profession and practice of pharmacy. For so the Pharmacy Act is there. Now the license for possession and use for rectifying denatured spirit, and the talk of the town, the Narcotic Drugs and Psychotropic Substances Act. This is the act because in in moderate amount, we can even use those drugs which are completely banned in India. But for the purpose of legal, for the purpose of medical, and for the purpose of life-saving drugs, we can use them. So, how a person be knowing about this fact? The person can knowing about the fact of the moderation, about the amount of drugs, about the amount of how a drug can be produced, what should be the limit. This can be governed by the Narcotic Drug and Psychotropic Substances Act. Now the VAT Act, Central Sales Act, Sales of Goods Act, and these all are the acts which are involved in manufacturing of drugs. Now, one more thing which make even a drug manufacturer liable for punishment is the adulteration of drugs. So, if a person whoever adulterates any drug or medical preparation in such a manner as to lessen the efficacy or change the operation of such drug or medical preparation, or to make it noxious, intending that it shall be sold or used for, or knowing it to be likely it will be sold or used for any medical purpose, as it had not undergone such adulteration, shall be punished. Now the thing is, even the drug manufacturer adulterates the drug to lessen their efficacy, and even to change their operation so that they can sell so many drugs. So there are even the adulteration and in manufacturing of drugs, sales of drug as different drug or preparation, which is now which attracts IPC section 276. So if a person who sell drug as a different drug or preparation, and that too knowingly. So now the one more thing is how we can now protect our client. How we can protect our client out of it. If somebody make him liable for adulteration of drug, and if somebody is making liable them for sales of drug as a different drug or preparation, and make them liable under these section which are just been we can protect our client, because in criminal cases, what thing has to be considered is the intent, is the knowledge of a person. So even if we are going through the definition of these sections, we can find out a word which is very important, and that word is knowingly. So the intention should always be there for committing an offense. Actus reus and mens rea, as we all know. So whoever knowingly sells or offer to sell or issues from a dispensary for medical purposes any drugs or medical preparation as a different drug or medical preparation, he shall be punished. Now we can protect our client by proving that his intention was not that of adulteration and was not that of selling the drug as a different drug or preparation. So in the before the court of law, in all criminal cases, which only one thing which we have to consider is which we have to take care is the intent of a person, that
Sir,
whether.
your voice is not clear.
Hello.
Sir, your voice is clear, no problem, sir.
So now I can repeat it, that for protecting our client, as we have said, we have only discussed the punishment. We have only discussed the how a person can be liable under section 274 and 276 for adulteration of drugs. We can protect them by proving their intention was not that of committing the, and as the section itself says, that a knowledge should be there. A person should knowingly be selling or be adulterating that drugs. So we can protect them by proving that their knowledge was not there. So they were not intentionally adulterating and selling these drugs. Now the other thing is negligent conduct with regard to poisonous substances. This a person can be liable for offense under section 284. Negligent conduct with respect to poisonous substances. Now the poisonous substances, as we all know, these are used in chemotherapy. There are so many things which a person is being like, is which the doctors use these kind of poisonous substances even to cure the dangerous diseases like cancer and all these things. So whoever does with any poisonous substance any act in a manner so rash or negligent as to endanger human life, or to be likely to cause hurt or injury to any person, or knowingly or negligently omits to take such order with any poisonous substance in his possession as is sufficient to guard against probable danger to human life, for such poisonous substance shall be punished with imprisonment of either description for a term which may extend to 6 months. So 6 month uh, imprisonment is being provided for negligent conduct of poisonous substances or to use poisonous substances in making or manufacturing drugs. Now, the other thing which we can advise, being a startup, to a manufacturer of drugs is or to a hospital or doctor is the blood bank regulation under Drugs and Cosmetic Act rules, the Homeopathic Central Council Act. These all things are there. Now, one more thing is very important, that we can also make educate even the doctors about the medical negligences, because the cases of medical negligences, as we all can see, are on a high. So how this can be traced, how it's a very technical issue, that a medical negligence, how it can be traced or how it can be investigated. Because if we talk about operation, if we talk about prescription of drugs and all these things, so an operation can be done in an operation theater in an isolation, and even the complainant, or we can say a victim, is not conscious, is unconscious at the time of conducting the operation. So to reach to conclusion or to investigate is a very technical, hyper technical issue, and we have to know about the, even to we have to know about the negligence, that how it can be said to be a negligent, and how a doctor can be liable for that. The consequences which a doctor can face for negligence, or for their negligent act, if we can say, so we can make them aware that not only a criminal liability, there is a monetary liability, there is a disciplinary action which can be taken against a doctor for medical negligence. We can also discuss the term medical negligence, that it can be referred to as wrongful action or omissions of a professional in the field of medicine in pursuit of their profession while dealing with patient. So it may not be termed as a conclusive definition, but we can reach to that conclusion that something wrongful act has been committed. Like a person, if he is not if he can be cured by medicines only, for say, we these days, if a person with an acidity problem, or with approaches a doctor, we can, so these cases are on the rise, that a person who is facing, or who is suffering from a gas problem, gastric problem, or acidity, doctor changes their valve and changes the and changes their and stunts, they implant stunts and all these things. So they done a hard. So these things is like there. So we have to first of all prove that that a person was suffering from only a gastric problem or from acidity and all these things, and the doctor knowingly with the intention has conducted a heart surgery on it. So this thing is can be termed as medical negligence, and it has a criminal liability, monetary and disciplinary action are always there. Now, for instance, we can discuss 304A IPC for medical negligence also. If a person is died because of the negligence of a doctor, and if it is proved beyond all reasonable doubt, so for reaching to a conclusion in a criminal case, it shall be beyond all reasonable doubt. If it is beyond all reasonable doubt that a negligent act has been committed by a doctor, so he can be punished with 304A IPC and can be led to imprisonment for 2 years. Now the civil liability is the monetary compensation, and a person can always approach a civil court, or we can say a permanent lok adalat, and can also upload, and if he is not rich, or if he is not have means to approaching this court, he can take legal services from the legal services authority, which are there under the Legal Services Authority Act 1987, and can knock the door for the monetary compensation. So the other thing is that not only the monetary compensation and not only the criminal liability, a person can also approach uh, uh, the disciplinary committee of the IMC, Indian Medical Council, and can get the license cancelled of the doctor who has committed who has committed the negligence. So these are the things which a startup should know uh, before going into the medical legal kind of a thing, that nowadays it's not only a conglomeration of these two ideas, and how these can be, like how these can be joined together, a medical profession and a legal profession. If a person is having the knowledge of medical, if we say that if a person is doctor and has also having the legal knowledge, can do these legal medical legal startup, and can help the insurance companies, and can help the doctors, can help the drug manufacturers with all the things which we have discussed today. And not only that, if a lawyer being a law student, if we know all these if we know all these things, if we know the faces of MNC, if we know how the MNC should be prepared, and if we know that what kind of laws are for manufacturing drugs, and for manufacturing drugs and cosmetics and all these things, and and also being a lawyer, if we are having a broad knowledge of the consequences which a doctor can face for medical negligence or all these things, we can advise them, and we can help them for for letting them know that you can manufacture at that time, and you can escape from the legal clutches by taking care of all these things. by taking care of the law which are governing in manufacturing, by taking care of law which are there. If you commit some kind of adulteration, and if you are committing some negligency while conducting an operation, or while all these things. So this, for these all ideas, I am concluding my lecture today. I'm Tanushi ma'am.
Yes, sir. Yes, sir. I'm Ishita here.
Ishita ma'am. Actually, it's Tanushri, which is visible to me.
Yes. Yes.
So, including my lecture with all these things.
Thank you, sir, for providing us all the knowledgeable information. I hope this lecture was very informative and knowledgeable for everyone. We are really grateful to Prabhat Kaushik, sir, for informing us and providing us about the medical legal knowledge of cases. And in the end, I would like to thank you, sir, for being part of this activity and being our guest. We would like to see you in all the future activities. So thank you so much, sir.
Thanks a lot, ma'am. Thanks IIMT for inviting me, and Professor Sudhakaran. Thanks a lot.
Thank you so much, sir. We are winding up the lecture. Thank you, students.